Hey guys, welcome to this video. My name is John Watts. I'm a lawyer in Alabama, and we're going to talk about a very recent case, came out last month, January 24th, that talks about RESPA claims, R-E-S-P-A, so those are claims against a mortgage company, and also the FDCPA, Fair Debt Collection Practices Act. Now, there's other parts of this opinion that we're not really going to look at because they're not as important for our purposes, but I think you'll find this interesting. And so let's see what we've got going on here. So this is a lawsuit against Deutsche Bank and also against Ocwen. And these are claims under RESPA and also the FDCPA. And as I mentioned, there's some other claims. And because there are some federal claims here, this case was removed or taken from state court to federal court. And then the defendants, both Deutsche Bank and Ocwen, said, "Judge, dismiss this case. Get rid of this case. There's no way the plaintiff can win." And so that's what this judge, who is Magistrate Judge Jennifer Hall, she is making a recommendation that part of that motion be granted, but then part of it be denied. And so just real quickly about magistrate judges. So we think of federal judges as being appointed for life, whether Supreme Court or appellate court or the trial judges called district court judges. Magistrate judges are not appointed for life. They're appointed for, I think it's usually 10 years. And what they do is they help the district court judges. Now, if both parties agree, and we're encouraged to do this, then the magistrate judge can have full power over our case. But evidently that did not happen here. And so the magistrate judge sort of takes the first crack at it, gives a recommendation. And in my experience, the district court judges tend to treat these recommendations very seriously by the magistrate judge. And so anyway, that's what we've got here. So we're not going to look at all these facts because it gets a little convoluted, but the plaintiffs had a home loan, and at some point they enter into a HAMP modification, Home Affordable Modification Program. And so then later Deutsche Bank becomes the owner of the mortgage. And then we have this company that's not a party, but they are showing some problems with the escrow account, even though the plaintiffs have been making all their payments on time. And so they're still having problems. Then Ocwen takes over, and Ocwen is a, how can I put this, an infamous mortgage company. They are just notorious, in my opinion, for doing a lousy job dealing with consumers. And so anyway, they take over and they send a mortgage statement that has $16,000 past due. And so then they refuse and return the plaintiff's mortgage payment. So what do plaintiffs do? Well, they get a lawyer to help them, and they finally sue, and they eventually enter into a settlement agreement. You think everything's going to be great. And then after the settlement agreement, Ocwen continues to send statements with bogus stuff on it. And then they say, hey, you're $3,000 short in your escrow account, and we need more money. And they're reporting, Ocwen's reporting that the plaintiffs were late to the credit bureaus, and they wouldn't fix that. And so the plaintiffs continue to make payments. They get some help from Legal Services Corporation in Delaware. They send some letters, and Ocwen responds with false information. They start holding the monthly payments in suspense. They're threatening foreclosure. And suspense is just where they say, it's not going to be applied to your account. We're just going to kind of stick it over here in the side, and we'll leave it there. And at some point, we may apply that toward your monthly payments, or we may return it to you. And so Ocwen is saying, we're not going to take any more money. You better pay all this off if you want to sort of get back in our good graces. So plaintiff stops making payments because Ocwen's not accepting them. And here's where we get to the interesting part. So the plaintiffs sent 7 notices of error and requests for information. Let me stop right there. Mortgage companies and their lawyers are notorious for this. They will describe those as qualified written requests. They are not qualified written requests. That's what we called these things back before 2014. Now they're called notice of error, where you tell the mortgage company, I think you've made a mistake in your servicing of my loan. I want you to fix it. And request for information, where you say, hey, mortgage company, I want some information. I want some documents about why you did this or that in the servicing of my loan. Now, the lawyers that defend mortgage companies will always reach back to older case law before 2014, when the law was changed, and talk about qualified written requests. And they want the judges to use that expression. That is not the right expression to use. And so this judge is going to, we'll see, use the correct expression here. So what are all these letters designed for? It's to get Ocwen to correct the account. Ocwen said, nope, we're not going to fix it. Here's the proof that we're doing it right. And they sent records that had all sorts of errors in them. So the plaintiff sued and said, hey, we have damages. Well, what are your damages? It's messed up our credit rating, caused us to be denied credit. It's caused anxiety, stress, mental anguish. And we've been charged fees for late payments or delinquent payments. And they also note that Ocwen was sued in 2017 by the United States Consumer Financial Protection Bureau and said they've repeatedly improperly calculated loan balances, misapplied borrower payments, failed to correct process escrow and insurance payments, failed to properly investigate and make corrections in response to consumer complaint. In other words, everything that a mortgage servicer is to do, Ocwen can't do any of that right. And so the plaintiffs very correctly point that out. And so they sue for a bunch of things. And the defendants moved for summary judgment. Plaintiff said, hey, I'd like to be able to argue this in person. And so that happened January 17. All right, so what's the legal standard? This is under 12b-6. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. Well, what does that mean? Plausible means factual content that allows the court to draw the reasonable inference that the defendant is liable. And it doesn't mean that the judge has to say, well, I think the plaintiff is going to win. It's just the judge has to say, is this plausible that the defendant could be at fault? And we have another quote, where the complaint pleads facts that are merely consistent with liability, it stops short of the line between possibility and plausibility. So you've got to actually put some facts in there. And there are some times where that's very difficult to do and the standard will be lower, but we'll see here how this plays out. So what is RESPA, first of all? It's a law that is a consumer protection statute that regulates the real estate settlement process, including servicing of loans. And that's what we're talking about here, servicing loans. So sending out monthly mortgage statements, calculating escrow, calculating late payments, credit reporting, all of that is going to be servicing. Now, the judge says their first argument or their first count or first cause of action under RESPA, the plaintiff should lose because there's no private right of action. So they say, look, we did not get accurate annual escrow statements. And the court agreed with the defendant, and really the plaintiffs also agreed that there's no private right of action under this. So sometimes in these statutes, the judge has to look and see, okay, there's an obligation on the part of the defendant, but can the consumer sue for that? Or is this something that only the government can sue? And we're not going to look at very much of this, but it just says, courts considering the issue have concluded there's no private right of action under 12 U.S.C. Section 2609. So we won't really look anymore at that. But how about sort of the more normal RESPA claims when you're dealing with the servicer? So they say, hey, look, Ocwen failed to properly respond to our notices of error. Remember, that's where you say, hey, mortgage company, you made a mistake. I want you to investigate and fix it. And request for information where you're saying, give me information, Ocwen. I need documents. I need information about your servicing. And so the plaintiffs say they didn't respond. And Ocwen admits that there's private right of action, but they say, we got some reasons why the plaintiffs cannot sue us, and the judge rejects all those. So what are we doing here? Well, we've got this section, 2605 requires loan servicers to respond to certain borrower inquiries, and this again is the older language, how we refer to them as qualified written requests, that request information from servicer or assert an error. And then the law tells us what the loan servicer like Ocwen must do when they get these. And so for notices of error, the loan servicer must generally either correct the error. If they do that, then they're fine. Or conduct a reasonable investigation and determine there's no error that occurred. And so how long do you have to sue? Well, you have 3 years to sue from the violation. So Ocwen says, well, look, some of the responses to those requests, be notice of error or request for information, fall outside that 3 year, and therefore you can't sue us for that. And then they say, and look, this is one of these really clever arguments that's too clever. They say, and the responses that fall within that limitation period, we didn't have to respond to those because they were duplicative. They were just duplicating what we had failed to respond to before, and it's too late to sue on those. So really, overly clever argument here. And the court says, well, you're right, that you do not have to respond to a duplicative notice of error request for information. So here's the law. Loan servicer is not required to conduct a reasonable investigation if it reasonably determines the asserted error is substantially the same as an error previously asserted by the borrower for which the servicer has previously complied with its obligation to respond. Now, of course, with Ocwen, they didn't comply. So that's a problem with their argument. But let's put that aside. This is really important. Regulation X, which is the thing that gives us the RESPA law, requires a loan servicer to notify the borrower if the servicer determines that it need not respond to a request because it's duplicative. So what this is saying is, okay, mortgage company, if you think this is just the same request over and over, you don't have to respond, but you do have to tell the consumer, here's the reason I'm not responding, because it's duplicative. And that way the consumer then can say, okay, you're right. Or the consumer can say, no, you're wrong. Here's why it's not duplicative. But what you can't do is just ignore it. So let's see what happened here. Ocwen treated at least one of plaintiff's requests within the limitations period as non-duplicative. And we have here at oral argument, let's see. Counsel for Ocwen acknowledged must notify the borrower in accordance with the site here that is determined it need not respond. Otherwise, it must conduct a reasonable investigation. And so the argument is, well, look, you failed to conduct a reasonable investigation in response to this August 27, 2018 notice of error. The response is that, let's see here. The response states that Ocwen acquired the servicing rights to the loan and there's a negative escrow balance of $4,300, even though that's not true. And so the judge says, well, then it's plausible that they failed to perform a reasonable investigation. And here's a cite to an older case, but still applicable. When you send contradictory responses, that suggests the defendant has failed to conduct a reasonable investigation. Okay. So let's kind of review. They must respond unless it's duplicative, but if it's duplicative, they have to tell you it's duplicative. If they don't, then they have to respond to it, even if it technically was duplicative. And then Ocwen says, well, you don't have any damages. You haven't plausibly alleged any damages. And the judge says, I disagree. There's two types of damages. Number one, it can be actual damages suffered by the borrower as a result of the violation. And then number two, statutory damages if the borrower can demonstrate a pattern or practice of noncompliance. So when you have a company that's just repeatedly violating the law, that can be statutory, and that can be up to $2,000 per violation. So A plaintiff must plausibly, remember that's our test under Rule 12b-6, is it plausible, in a motion to dismiss, is it plausible? You must allege at least one type of damage. Now you could allege both types. And here the judge says, well, they've plausibly alleged actual damages. So they paid some postage fees to send the notices of error. Always send these by certified mail. So each letter you send should have $5, $6, $7 in postage charges. And the defendants acknowledge that postage fees to send a non-duplicative notice of error are actual damages within the meaning of the statute. Now remember, it is not duplicative unless it really is, and the mortgage company tells you within that time period that this is duplicative. So the defendants are saying, you know what? The ones we didn't say were duplicative, yeah, you get to recover your postage fees. Now, I will say this. There's some disagreement among courts on this. Some say that your initial sort of round of letters, you cannot get the postage for. But then when it's not fixed and you continue to try and get it fixed, then you can get your damages for the postage fees. So here's some cases here. Postage fees for mailing qualified written requests. Remember, that's kind of the old way of saying this. Metamorphosed into damages when the servicer failed to respond as required. And then counsel, this would be counsel for the defendants, also acknowledge damages based on harm to the borrower's credit are also recoverable, as are emotional damages where there are other pecuniary damages. Now, the law, at least in most places, is even if you don't have any pecuniary, which is just financial loss, you can still recover emotional distress damages here. But it's nice when you do have something, even as small as, hey, I got $20 or $50 in postage fees. That is economic damages, pecuniary damages. And so that can be very helpful. So the complaint alleges Ocwen's actions have caused plaintiff to be denied credit, and they've suffered emotional distress in the form of stress and anxiety. All of those may result in actual damages. So here's a case from the 7th Circuit Court of Appeals denying defendant's motion for summary judgment regarding existence of actual damages, where plaintiff was denied credit and suffered emotional distress. Now, what about the statutory? Well, they have to allege pattern and practice. And it says, let me get this highlighted. While the parties dispute whether violations as to a single borrower, or in this case it's really two people, but still that would count as sort of one, as a single borrower can amount to pattern and practice. At oral argument, Ocwen acknowledged that a complaint plausibly alleges pattern and practice if it references another case in which a plaintiff alleged a loan servicer committed similar RESPA violation. Now, we'll tell you this, in the 11th Circuit where I practice, which covers Alabama, Florida, and Georgia, the 11th Circuit has said if it's one or two letters from the same borrower, that's probably not going to be enough, or at least one or two kind of discrete, specific items. But when you start getting into 4 or 5 things that you're talking about, that probably is going to be enough. And that's a case against NationStar from a couple years ago. But here's what the plaintiff did that was very, very smart here. And that is to reference the government going after Ocwen. So let's see what the judge says about this. Plaintiff's complaint does that. Paragraph 46 alleges Ocwen was sued in 2017 by the CFPB, which alleged that Ocwen failed to properly investigate and make corrections in response to consumer complaints. Hey, that's exactly what a notice of error request for information is. And so the judge says, accordingly, I conclude the complaint also sufficiently alleges statutory damages. Now, the judge says, you don't have a RESPA claim against Deutsche Bank. Well, why is that? Well, because it only applies to servicers and Deutsche Bank is not a servicer. Okay, so how about the FDCPA, Fair Debt Collection Practices Act? And if you've watched our other videos, a lot of this will be familiar. But this gives a cause of action, the ability to sue on behalf of consumers who have been subjected to abusive, deceptive, and unfair debt collection practices. And so here's how the judge in this particular case sort of organizes this. It says you have to have 4 things. 1, you're a consumer. Number 2, the defendant is a debt collector. Number 3, defendant attempted to collect the debt. And number 4, they violated a portion of the FDCPA when they did that. So, what are the arguments from the defendants here? They say, we're not debt collectors, and we didn't do anything within the 1-year statute of limitations. So you only have 1 year to sue from the violation of the law. And the judge says, well, it only applies to debt collectors. So what's the definition of a debt collector? Well, there's two ways that you get it. Number one, somebody who uses any instrumentality of interstate commerce, so things that travel or affect business or commerce between two states, or the mails in any business, the principal purpose of which is the collection of any debts. So this is known as the principal purpose definition. Or number two, someone who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due another. So this is what's known as the regularly collecting definition. But it does not include somebody who's collecting a debt that was not in default. So the plaintiffs don't say Deutsche Bank is a debt collector. So Deutsche Bank is out of this. But Ocwen may be a debt collector under the FDCPA. And the court points out plaintiffs have not alleged facts plausibly suggesting Ocwen is a debt collector in the principal purpose definition. And I'll say, they should. This is the purpose of Ocwen. This is what they're doing. But the judge says they may satisfy the regularly collects definition. Now, Ocwen, they do something that every single mortgage defense lawyer does, at least in every case I've been in. And they say something to the court that if it's not untrue, it's incredibly deceptive. And that is, they say, hey, mortgage servicers cannot be debt collectors. That is absolutely false. Okay? And the judge says that's not the case. A mortgage servicer who regularly collects debts for another may be considered a debt collector. And added on to that is the debt has to be in default at the time, or the mortgage company must say it's in default, even if it's not in default. So the court says there's enough here to satisfy that. And let's see, plausibly suggest it is a debt collector. So Ocwen self-identifies as a debt collector. So they say things like this communication is from a debt collector attempting to collect a debt. That's a plausible inference. It's usually not the winning argument, like, you know, you don't have to have anything else but the little thing at the bottom of the page that says from Ocwen, hey, we're a debt collector. But it is persuasive to have that. Now, here's where Ocwen tries to get really cute here. And again, this is a very typical tactic. So I want you to understand, if you're suing a mortgage company, whether you're doing that your own, whether you're a lawyer watching this, this will come up. They say, hey, we're excluded from being a debt collector because the plaintiffs have said they weren't late when we took over the loan. And just ignore the fact that we kept telling them that they were late. So Ocwen's saying, you know, the truth of the matter is that the plaintiffs were not late, so therefore we can't be debt collectors. And the court goes, no, not even close here. So I disagree to the extent Ocwen argues it cannot be a debt collector and cannot be liable for violations where the plaintiff disputes a debt was owed in the first place or that the plaintiff was in default. As other courts have concluded, Ocwen cannot escape coverage under the FDCPA by asserting to the court the debt was not actually in default, despite having done plaintiffs, in other words, collected against plaintiffs for months or years in face of plaintiffs' pleas or proof the collector has made some error. So you can't say, you owe all this money, you owe all this money, you were late when we took over this debt. And then when you get sued, go, actually, we were wrong. And since we were wrong, we have immunity for all the lies we did. That's not how the law works. And actually, it's a very simple way to prove this under the definitions, under the FDCPA. And we have a video on this. So this would be, let's see, 1692A, I believe is the definitions, if I remember right. Or maybe it's just 1692. But anyway, it's one of our first or second videos on the series of going through all the text of the FDCPA. It defines what a debt is and what a consumer is. And it talks about where you owe or you are alleged to owe a debt. So even if you don't owe the debt at all, I mean, you could never have this debt and a mortgage company says you do, well, they're a debt collector and the FDCPA applies even if you truly were never late. So then the court says, Ocwen says, look, the plaintiff didn't sue within the 1 year. And this is interesting. The judge asked plaintiff's counsel to identify at least one alleged debt collection activity by Ocwen within statute of limitations. They were unable to point to any document described, but they said there are mortgage statements being sent and they would amend the complaint. And Ocwen said, yep, we understand, and this is true. Mortgage statements can be debt collection activity, and it would not make the plaintiff amend the complaint just to do that. So, judge says the FDCPA applies. Now, the rest of this gets into other stuff, breach of contract, fraud, negligent servicing, breach of implied covenant, unjust enrichment. And I'm not going to cover that because that gets real specific into each state law. And I really wanted you to see the federal stuff here. So if you're dealing with a mortgage company, if you're dealing with Ocwen, if you're dealing with these other mortgage companies, understand the power of RESPA in sending out those notice of error, request for information letters. I will point out, if you do those letters and the servicer, your mortgage company, has designated a specific address to mail them to, you have to mail it to that address. You can't just mail it to any address of the company. They just throw them away. They don't do anything with them. You've got to send it to the specified address. That'll be on your mortgage statement. It'll be on the website. You can always call them. And so definitely look for that because most companies have that. And then remember the power of the FDCPA, Fair Debt Collection Practices Act. So appreciate you guys sticking with me. Hope that this is helpful to you and that you enjoyed this. Let me know if you like these kind of videos, and I'll continue to do these from time to time as I see kind of an interesting case or maybe something that's a little bit different or a little bit new. And thanks for watching this, and I will catch you in the next video tomorrow. Okay, bye-bye.